It happens in the workplace every day. Boy meets girl. It's a natural thing, but sometimes it's a crime. Then it's called sexual harassment. True stories and Carrie Ellison right here on Final Take.
I did not sexually harass Serena Weeks. Period. I did not sexually harass Serena Weeks.
This shouldn't have happened. This is a guy who is a supervisor of a department, a big department in this firm, and it shouldn't have happened, and I couldn't understand what was going on.
I never, in the farthest reaches of my mind, can't imagine that my friendship with her would be considered sexual harassment.
I think that she wanted to save her job.
You can see that it was not anything to be alarmed about.
I don't think an employer can safely say that he knows that this is good nudity and that's bad nudity in the workplace.
I have a very unique perspective on sexual harassment from the woman's standpoint. As a victim, she would put her hand around my waist and make me feel very uncomfortable. And she'd come in dressed unusual. I told her that I was going to go to her boss and that I couldn't take this anymore.
Good evening, I'm Renee Poussaint, and this is Final Take. Our topic for this evening is sexual harassment. As we've just seen in the movie Hostile Advances, there is nothing sexy about sexual harassment. In fact, victims say words like shock, fear, and anger describe it better. We'll walk a tightrope together tonight to explore this powerful issue. When does innocent attraction become ugly intrusion? Where do we draw the line? And as our personal and professional lives become more intertwined, what behavior crosses the line? Sexual harassment laws are a work in progress. They are constantly evolving. But one fact does not change. A harassment-free workplace is every American's right, man or woman. Sexual harassment is against the law. In tonight's program, we have a panel of experts who are going to help us understand just what sexual harassment really is. But first, Bonnie Strauss tells us more.
Men and women together on the job. It's natural for people anywhere to be attracted to each other. But at work, it can be risky business. Whether you are an entry-level office worker or occupy one of the highest offices in the land. A nomination to the highest court in the land uncovered the less than honorable actions of a Supreme Court justice nominee.
I was afraid of retaliation. I was afraid of damage to my professional life.
I think this whole affair is sick.
And sexual harassment continues to grab headlines, as the largest case to date is filed by auto factory workers against Mitsubishi, as actor George C. Scott faces harassment charges from a personal assistant, and as Bo Derek charges Warner Vision Management of sexually harassing her in a movie role. Sexual harassment is any unwanted attention of a sexual nature. It can be physical or verbal. The victim can be a man or a woman. The harasser can be a man or a woman. It is hostile. It's intimidating. It interferes with a person's ability to do their job.
If I ask you to lunch and I'm your boss, you never forget that I'm your boss. I think there's a lot of confusion about gender relations, and what we're looking at is how do we negotiate being together.
The sex with me or I'll fire you scenarios get the most attention, but are only 5% of all cases filed with the EEOC. 95% of sexual harassment cases result from what is called a hostile environment. Email, pin-ups, jokes, even strippers at an office party. Bad taste? Probably. Illegal? The law says yes. These actions could create a hostile environment. Hollywood made us aware of sexual harassment as a social issue. In hit films like 9 to 5 and Working Girl, the theme is sex with the boss equals job benefits. Often what a victim heard isn't what the alleged harasser said or meant. Touching or a gesture can also be misunderstood. Experts suggest some problems classified as harassment are really problems of communication.
Being an adult, we ask people to distinguish between having a feeling and acting upon it. Not every time we have a feeling do we have carte blanche to act on it.
Harassment cases are as different as the people they involve, but one truth is certain. Unwanted sexual advances aren't part of advancing on the job. Sexual harassment is not only unwelcome, it's against the law.
As you can see, sexual harassment is as individual as the people involved. Joining us with their experience on the front lines of this problem are our very distinguished panel members. Feminist and attorney activist Gloria Allred, the director of the National Center for Men, Mel Feit, a national consultant and leading researcher in harassment and discrimination issues, Dr. Frida Klein, director of Klein Associates in Boston, founder of Organizational Training Incorporated and a member of the Sex and Law Committee of the New York Bar, attorney Mitchell Karp, a constitutional lawyer specializing in broadcast and First Amendment issues, Muriel Reese, and a very special guest. You just saw her story on the movie Hostile Advances. Her case took 8 long years to be resolved, and she is here to share that real-life struggle with us. Everyone, welcome Carrie Ellison. As Carrie said, taking on the IRS, our first story this evening is another David and Goliath saga. A legal secretary sexually harassed by a senior partner at the world's largest law firm. What could she do? Bonnie Strauss found out.
He put his knee in my lower back and pulled me back. My leg went up. He pulled me back and he said, "Let's see which breast is bigger."
Rena Weeks used to be a legal secretary working for a very powerful attorney named Martin Greenstein. Greenstein was one of the partners at Baker McKenzie, the largest law firm in the world.
They have approximately 30 countries in which they have offices, approximately 50 offices. They have 1,700 lawyers. And at the time, they were grossing approximately $550 million a year. The partners, there were approximately 530 partners, were dividing up approximately $190 million a year in profits.
Philip Kay and Alan Axelrod never thought they'd be taking on the world's largest law firm when they agreed to represent Rena Weeks in a sexual harassment case. But when they heard the details of the abuse, they simply couldn't resist.
Baker McKenzie was taking care of a powerful partner at that firm, and they didn't care about the people that he was abusing. They didn't care at all about the women that were complaining. They just simply didn't care.
I did not sexually harass Rena Weeks. Period. I did not sexually harass Rena Weeks.
During the trial, Rena testified that when she began working for Greenstein in July of 1991, the harassment began almost immediately and got progressively worse.
She went to lunch with Mr. Greenstein and others at a local Sizzler in the Palo Alto area. Upon leaving that lunch, Mr. Greenstein asked her if she would like a ride back to her word processing training, and she agreed. And when they got behind the Sizzler, when they were out of sight and out of view of the public that would be walking by the restaurant, he assaulted her. And the assault was very serious. He came up from behind her. He was holding some M&Ms in his hands, and he reached over her shoulder, and he's a big man. He's approximately 6'1", he weighed 300 pounds, and he reached over her shoulder and he deposited these M&Ms into her breast pocket. And as he dropped them in, he grabbed her breast as he was removing his hand.
I couldn't believe what happened. I was in shock. I was thinking, this shouldn't have happened. This shouldn't have happened. This shouldn't have happened. This is a guy who is a supervisor of a department, a big department in this firm, and it shouldn't have happened, and I couldn't understand what was going on.
What I did was use humor inappropriately, kid around with people, criticize people. I didn't sexually harass people.
Weeks reported the harassment to management and claims Greenstein retaliated. She said he then began to harass her on a daily basis, and she started to be written up for bad work performance.
Every time that man walked into a room, Rena Weeks jumped like a little animal that was scurrying for some dark place to hide. Because Mr. Greenstein was a brute, and people like him pick on people that they believe are good victims. and he saw Miss Weeks as someone he could take advantage of.
Weeks, it turns out, may not have been the only victim. 6 other women testified that over the years, they too had been subjected to Greenstein's unwanted sexual advances.
We were able to eventually discover that there had been complaints dating as far back as 1987, when Mr. Greenstein had worked in the Chicago office of Baker & McKenzie, which is their world headquarters. And this was not the first complaint by any means.
Barbara Giel was the foreperson on the jury. She did not believe Rena Weeks was sexually harassed.
If anybody had ever put their knee in my back or touched me in any way, maybe I would have hit him and I would have ran away. I felt by her testimony and her actions that she didn't perceive it as being so outrageous, so offensive, and so harmful.
Maureen Randolph was also a juror, but she had no sympathy for Greenstein. She knows all too well what it's like to be sexually harassed.
I myself, when they were selecting the jury, said that I felt that I had once been harassed at work, and I was surprised they let me even be on the jury. And I know how upsetting it can be to go in every day and have someone harassing you, cutting you down, demeaning you, and how difficult that can be.
Barbara Giel was the only juror to vote against Rena on the sexual harassment charge.
This particular case was hard because I was so torn. It's an issue that's close to all of us, especially women, and I just was torn because I couldn't vote yes, and I was in the minority.
Has the jury reached a verdict?
Yes, we have, Your Honor.
What amount do you award to plaintiff Rena Weeks for emotional distress caused by the sexual harassment? Answer, $50,000. We assess punitive damages. Defendant Martin R. Greenstein, $225,000.
But what came next astounded everyone, including Weeks herself.
We assess punitive damages against the following named defendant as follows. Defendant Baker and McKenzie, $6.9 million.
$6.9 million, all awarded to Rena Weeks. This was the largest verdict ever handed down in a sexual harassment case. In the end, the judge reduced the amount to $3.5 million. The case is on appeal.
I think the award of $6.9 million was way over the top for what happened. But the jury didn't award the money to her as much as they punished Baker McKenzie.
They could afford this. They needed to get their spanking, and this was going to be their spanking.
Greenstein still says there was no sexual harassment, but the jury decided otherwise, voting to give Weeks an extraordinary award. You heard it, $6.9 million to an employee who worked for the firm only 3 months. Even when the judge later reduced that award to $3.5 million, that's about $40,000 for every day she worked at the firm. Now, as someone, Carrie, who has suffered through the trauma of a harassment case for 8 years, is that an excessive amount of money, or can you weigh these things in terms of amounts of money?
When I first went to court, there were no penalties that you could get for sexual harassment. I think there weren't any until the new law came out. So, and that's when you see now sexual harassment is being taken more seriously now, because there are dollar ramifications to companies if they don't do it, and so it gets their attention. And if that's what they're trying to do, I think it was effective.
Mr. Fight, what do you think?
I think there are people who lose arms, legs, are seriously injured, get a lot less money than that. You bet it was excessive.
Okay. Ms. Allred, you've had a lot of experience with these kinds of cases. The idea, one of the jurors said, was to punish the company.
It does send a message not only to Baker & McKenzie, but to law firms and to other employers throughout the nation. Many companies now are reviewing their training policies, are reviewing their practices and their procedures in the workplace, so that employees will have a way to grieve if they have been sexually harassed, that they will know what their rights are, and perhaps they will be able to fight back.
Mr. Karp, you deal with these companies all the time. How effective is it? Are they really changing their policies?
Well, I agree with Gloria that this was a wake-up call to not only to Baker McKenzie, but to every corporation and professional organization in the United States. So it has served its purpose from a public policy point of view. When we talk about the dollar figure, I think we missed the point, that the organization had multiple opportunities to respond, to think about this, to try and intervene, and they opted not to. They opted to go through litigation to maintain a wall of defense.
But if, in fact, they didn't have to pay any money, if, in fact, this is all on paper, isn't the wall of defense still up? Aren't they still basically getting away with it?
They have a judgment sitting there of $3.5 million, and it's hanging over their heads. And I think it's very effective. Now, of course, they're going to appeal, and maybe it'll be diminished. But in the meantime, a story has been told to the whole world that this is not the way you behave, and when you behave this way, you're going to be punished, and that's exactly what punitive damages are.
With the fact that they're giving awards now, and they could be large awards, then attorneys are interested in these cases now. And with the way the law is changing, they have some chance that they could win and that they could win a lot of money. So you're going to get a better legal assistance.
I just don't think the problem is corporate. I think it's cultural. The solution has to be cultural. I think we live in a society in which men are still expected to make the initial sexual advance. You know, he pursues, he courts, he performs, he pays, he asks, she decides. It's a good system if you happen to be a woman. But if we're going to change the workplace, we need to start to share the roles so that both men and women run the risk of sexual rejection.
Renee, I think what Mel perhaps is missing is that sexual harassment is not just obnoxious, it is harmful to its women victims. They've been subjected to rape, they've been subjected to fondling, to obscene phone calls, to constant propositions on the job, to having their breasts grabbed, to having their buttocks pinched. This is not the kind of workplace that we should have for women or for anyone in this country. People are entitled to equal employment opportunity. They are entitled to a workplace that is free of harassment. And I'm proud of people like Carrie Ellison and Rita Weeks who have fought back so the workplace will be better for us all.
Now our audience is going to be the jury and consider the question, was $3.5 million an excessive award for the harassment Rena Weeks says she suffered at Baker McKenzie? You'll find out how our jury voted when Final Take returns. Stay with us here on Lifetime. Up next, Domino's delivers to one of its former managers, and we're not talking pizza. Welcome back. I am with our audience four-person, Ramona Rademacher, right?
Right.
I got it right, okay.
That's right.
Well, we asked our studio audience to be the jury and decide if $3.5 million was just too much to pay Rena Weeks for her sexual harassment charge against Baker McKenzie. Was $3.5 million an excessive award? What did our audience decide?
It was the decision by the audience that the award was proper.
Was it pretty evenly split?
On the contrary, it was 2 to 1.
2 to 1?
Mm-hmm.
In favor?
In favor.
All right, thank you very much, Ramona. Our next story attacks a common myth about sexual harassment. Many people believe it only happens to women, but a Florida man knows that's not the case because he was the victim.
I have a very unique perspective on sexual harassment from the woman's standpoint as a victim.
His name is David Papa, and he made history after a court agreed his boss made advances.
It was the first reported federal case that we could find where a male had won at trial after being sexually harassed by a female supervisor.
It all began 8 years ago when Papa was just 25, a single dad separated from his wife, and manager of a Domino's pizza store in Tampa, Florida.
At first, she would just come in and talk to me about, Dave, are you interested in dating again?
But Papa told the court the seemingly innocent curiosity of his area supervisor, Beth Carrier, soon revealed itself as something else.
She began rubbing my shoulders, and when I would tell her to stop, she would just tell me to loosen up. She would put her hand around my waist and make me feel very uncomfortable. And there was another time that she'd come in dressed unusual. She didn't have her regular Domino's pizza attire on. She came in with a blouse and a skirt. She looked at me and said, my bra slipped off, Dave. Does that turn you on?
The store manager and a supervisor were heading for a showdown.
One afternoon, she came into my office and she told me that she loved me. I told her to get the hell out of my office. I told her that I was going to go to her boss, and she got up very angrily, and she walked off, and she turned around, and she told me, we'll see about that.
A week later, Beth Carrier was good to her word.
And at that time, Beth Carrier looked at me and she said, I'm terminating you for, I believe she called it manipulation of company paperwork. Well, I almost fell down. I was absolutely beside myself.
Papa apparently had been framed, so he got a lawyer.
It was instantly apparent to me that I could prove that he was telling the truth and that his legal rights were violated.
The Federal Equal Employment Opportunity Commission was equally convinced Papa had a good case.
I discovered a witness that no one knew about, but this witness was totally unbiased, and he directly contradicted Beth Carrier's allegation of why she fired David.
The EEOC filed a sexual harassment suit against Domino's on behalf of David Papa, but it would be 6 years before he would get his day in court.
There were nights that I didn't think this trial was ever going to come to pass. When I was first terminated, I had a very difficult time getting a job. If I was to walk into a restaurant or a business establishment and put an application in, there was 2 years worth of time I'd spent at Domino's Pizza. So when they asked me my reason for leaving, I would have to tell them the truth. And when I would tell the manager I was sexually harassed, many times they wouldn't take it serious. I had one manager laugh at me.
Finally, in November of 1994, the case went to trial. And just last November, Papa was awarded $237,000 in back pay. The court also ordered Domino's to post a sexual harassment policy in every Domino's pizza store in the country.
When it was resolved, I broke out in tears. I mean, when my wife told me on the telephone that we had won the case, words couldn't describe how I felt. The only sad thing was my father wasn't alive to see me vindicated from this, because I did nothing wrong.
Domino's declined to be interviewed for this story because they are appealing the case. Let's turn to the panel now and ask, and I'm going to start with you, Dr. Klein. We haven't heard from you so far. Do we expect different standards of harassment for men as opposed to women?
I think we do. I think that there are notions about male and female sexuality that get muddled in our thinking about sexual harassment. Sexual harassment is really about abuse of power. It is the introduction of unwelcome sexual attention into our workplaces and should not be confused with welcome behaviors or dating rituals or other things that are of a welcome nature outside of work.
Well, it's interesting. Before the program started, I was chatting with the audience, and I asked how many in the audience had been sexually harassed in a professional setting. A number of women raised their hands. Not one man in the audience raised his hand in terms of having been sexually harassed in a work situation. Is that because it doesn't happen, or is it because it may happen, but we expect men to deal with it differently?
I think that the reason that it happens is because as a result of years and years and continuing sex discrimination against women, mostly it is women who were being supervised by men because the women, because of the glass ceiling, have not been often promoted to supervising men. And so therefore most of the victims are the ones who are not in power, that is women, because they are being supervised by the people who are in power, men.
I'll be honest with you. I'm not completely sympathetic with this guy, and I'll tell you why. A woman walked into his office and said, I love you. He said, get the hell out. And it's the same problem that I have with Carrie's case. You know what happened in her case? A man with whom she worked fell in love with her, and he wrote her love letters. They were a little awkward. They were a little, overbearing. He said things like, I cried over you last night. I admire your style. If someone says, I love you, you don't say, get the hell out of my office.
Carrie?
I don't think you've been ever sexually harassed, or you might have a little different viewpoint.
I beg to differ with you. No, I know, but I think men are under harassment every minute of every day in this culture. It's male sexuality that is constantly criticized, and I think that men are under attack in different ways than women.
Let's let Carrie respond, though. Carrie, I mean, there is a question on the table. Did you, in fact, talk to the person who was harassing you and try and get him to stop on your own?
Yes, I did everything I could not to have to, believe me, the last thing in the world I wanted to do was sue this person, but by the time you get to the part where he has an attorney and your attorney is talking to his attorney, he knows very well what's going on here.
I think the point is she was uncomfortable. Whatever he did was making her uncomfortable, and she had the right to be comfortable. She had the right to get up in the morning, go to work, and not feel uncomfortable, and that is what the court recognized, and he had no right to make her uncomfortable.
In a minute, the verdict from our own jury. During the break, the audience will cast their vote on the following question. Should there be different standards of harassment for men and women? Real people, real stories, and the burning issue, is it really sexual harassment? Welcome back. Once again, we're joined by our four-person here in the studio. Our audience has just voted on this question. Should there be different standards of harassment for men and women? Let's find out. How did the audience vote?
The audience voted that there should not be a different standard, and the vote was unanimous.
Unanimous?
Unanimous.
All right. Thank you very much. It's not unusual for each side of a sexual harassment suit to tell a different story. Facts can be vague, and what seems so black and white to the parties involved is often blurred and gray. When allegations are made in the workplace, what is the role of company management? What should a company do? And just as important, what should it not do? Bonnie Strauss discovered one such case that raises these questions.
I never, in the farthest reaches of my mind, can't imagine that my friendship with her would be considered sexual harassment.
John Kirsch was the publisher for the South Florida Business Journal out of Miami. A woman who we'll call Cindy was the advertising director.
There came a point where we, myself and those people above me, were in agreement that it was time to make a change in our advertising director. And that's when the problem began.
A problem that would leave this family man without a job, and his advertising director keeping hers. And here's where the story gets really interesting. According to Cindy, she and John had a consensual sexual relationship that started years before when they worked together in Maryland. John flatly denies that and says they were merely friends. But this is not a he says, she says story, but rather a story about what happens when allegations of sexual harassment are or are not properly investigated. Here's what happened. John says that because he and Cindy were friends, instead of just firing her, he gave her two options. He said she could be demoted and take another position at the Journal, or she could resign.
She had recently just gotten married, and I suggested that perhaps a way for you to save face and to take this other position would be that the pressure of the job, given your new family responsibilities, were causing you to decide that you didn't want to work under that pressure anymore.
Cindy was concerned she was being treated this way because she says they had a prior sexual relationship. She wrote a memo which said, "I consider these comments about my marital status to be discrimination, and I hope they did not stem from our prior relationship." She gave the memo to John, his supervisors, and faxed it to corporate headquarters.
The next thing he knew, while he was on vacation, which she knew he was on, he had been accused of sexual harassment. His boss called him and said, I got a memo. She's accusing you of having fired her because you had a romantic relationship and that you were jealous because she was getting married.
John assumed his bosses would at least hear his side of the story. He was wrong. The company saw the memo not as discrimination, but as sexual harassment. While on vacation, he was asked to resign effective immediately. His next call was to his attorney, Donna Ballman.
What the company should have done was they should have talked to her, which they never did. That's the interesting part, is they took the memorandum as truth. They interpreted it the way they interpreted it, was that it meant sexual harassment.
I think logic would tell you that a corporation sits there and thinks, what's our minimum damage we can do on this, purely in a dollar sense? And of course the answer is, we ask the person to resign, we give them a couple months severance, they go find another job, and we dodge the bullet.
But it was the company that never expected what happened next. John sued for defamation of character.
Your reputation is really all you have. if you think about it, and that if we walked away from that, it would always be lingering in our minds that we really took the easy way out and didn't stand up for what we believed.
But Cindy saw it differently. In a pretrial deposition, she goes into great detail describing the sexual relationship she says they had. He put his arms around me, came after me, tried to kiss me. But when she was asked whether she thought she was being sexually harassed, she answered no. The South Florida Business Journal settled soon after.
I think the most important thing I've learned is getting your priorities straight. Right now, my wife and I work together, and we trust each other pretty well, but we have no employees, and that's fine with me. I would have to think very hard before I would manage again because of this situation.
Although Cindy said she had not been sexually harassed, her boss was fired. Now, did South Florida Business Journal overreact to Cindy's claims? That's the question. Let me ask Ms. Reese, you've had a lot of experience with these kinds of cases. What do you think? Did the Journal overreact?
I think they obviously did, and one really big mistake was they didn't investigate. That's the very first thing that an employer has to do, is to investigate, and they ended up by being a defendant in a lawsuit.
I want to tell you that last year there was an article in Esquire magazine about a man who was an employee of AT&T, a 12-year exemplary record. Then one day a woman accused him of telling a dirty joke, God forbid. And without a hearing, he was suspended, demoted, fined, ejected from the premises, reassigned to Alaska, and it was too much for him to take, and he killed himself. I think that sexual harassment law is like giving every woman a loaded weapon and inviting her to point it at any man and for whatever reason to pull the trigger, and too often the trigger is being pulled.
I think employers have a responsibility, and this case shows it's in their interest as well to help employees have that dialogue.
Do most companies, in your experience, and both of you consult with a great many of these companies, do they have those kinds of guidelines for their employees?
I have helped many clients develop those kinds of guidelines. And guidelines is the perfect word.
Renee, I'd like to take issue with Mel's statement about women holding a gun to men's head. I think it's important that women have protection from sexual harassment on the job. I think that if there are dirty jokes on the job, if there are sleazy pictures on the job that are offensive to women, if there is grabbing, if there is touching, that women should have rights to fight back. They shouldn't be apologetic about it. They shouldn't be defensive about it if they do fight back.
I think Gloria's attitude is straight out of the 1950s. It's an attitude that said that women are too fragile, too delicate to compete in a, quote, man's world. What Gloria is saying is that women are fragile and need to be protected from offensive language and offensive ideas. I think it's demeaning to women. The problem here is that corporations are under such pressure from feminist attorneys like Gloria already to bring every case and punish every man, regardless of the evidence, regardless of the facts. What we need now is for men who are falsely accused to sue, and juries have to give them $6.9 million.
Well, okay. Our audience is obviously reacting, and our audience jury is going to cast their vote. Did South Florida Business Journal have the right to fire John Kirsch? The verdict in a moment when Final Take returns here on Lifetime. A painting on the wall of a city building tests the limits of sexual harassment. We are back with our audience foreperson, Ramona, and the verdict. Did South Florida Business Journal cross the line? Should John Kirsch have been fired after Cindy's complaint of sexual harassment? What was the vote?
The vote was the entire audience agreed except two, that he should not be fired.
That he should not be fired?
Yes.
And the two who voted?
Were men.
Were men.
Mm-hmm.
All right. No particular significance attached to that. We'll just leave that alone. Thank you very much, Ramona. Now, here's an interesting dilemma. What's more important, the right of free expression or the right not to be sexually harassed? We visited a small town in Tennessee where sexual harassment charges and the First Amendment collided head-on.
To some, it's a tasteful painting of a partially clad woman.
You can see that it was not anything to be alarmed about.
To others, it's viewed as sexual harassment.
I don't think an employer can safely say that he knows that this is good nudity and that's bad nudity, in the workplace.
Now this painting, titled Gwen, has turned the old Civil War city of Murfreesboro, Tennessee, into a constitutional battleground.
I knew my First Amendment rights had been violated.
This story of censorship and sensibility began several months ago when Gwen was hung in the rotunda of Murfreesboro City Hall. The painting was among a collection of 40 being displayed by local artist Maxine Henderson.
No one raised an eyebrow.
But Lori Crowder did. She's an assistant school superintendent who spotted the painting on her way to a board meeting. Crowder filed a sexual harassment complaint with the city.
I personally find art in any form, whether it be a painting, a Greek statue, or a picture out of Playboy, which displays genitals, buttocks, and/or nipples of the human body, to be pornographic, and in this instance, very offensive and degrading to me as a woman. I reserve the right not to have it thrust in my face on my way into a meeting with my superiors, most of whom are men.
Murfreesboro City Attorney Tom Reed went to investigate.
It was obvious when I looked at it that we were faced with a situation where this lady had no clothes on. I mean, she was nude.
Reed removed the painting and hid it in his office closet, satisfying Lori Crowder but enraging artist Maxine Henderson.
And what really hurt me was that I was the contributor, and someone could come along and say, take it down, a picture down. And that the city would honor her rights and not mine.
So Henderson, a 66-year-old grandmother, filed a complaint of her own, a federal lawsuit claiming the city breached her First Amendment rights to freedom of expression.
You know, somebody has to stand up and say, well, I'm going to use this for my protection.
City Attorney Tom Reed insists he was right in removing the painting, claiming a worker's protection from sexual harassment supersedes an artist's right of expression.
The female employees here, they don't have a choice. They have to, this is their workplace. So there is a distinct difference between a workplace and a museum where art is displayed.
It's both a working place and a public forum. Obviously, people work there, so it's a working place. But the city having chosen to utilize its facility as an art gallery, then from a constitutional standpoint, it becomes an art gallery.
In her suit, Maxine Henderson is asking for $1 and attorney's fees, insisting that she's fighting for a principle, not money.
The artists should have assurances that they're not going to be censored.
Meanwhile, she believes Lori Crowder's sexual harassment complaint only harmed her own cause.
I think it's sad that someone would trivialize this when there's so many women that possibly this law is so valuable to them.
We're back. Would you have removed the painting from the City Hall area? Let's ask the panel members. Anybody feel that the city officials took the proper action by removing the painting?
Well, I think there's just a very dangerous trend here. I think we're headed down a slippery slope where the posting of artistic material or political material that offends people can be regarded as sexual harassment.
I think we have to look at the content. In this issue, I think we have to look at whether or not this is, in fact, that employee's workplace.
Dr. Klein, you go into a lot of these companies. Do you tell employees or do you tell employers that if there's a picture of a nude woman up on a wall that it has to be taken down? Is that sexual harassment? How closely do you call these things?
Well, I think we keep losing perspective here. When we're talking about a workplace or an educational institution, we're talking about a captive audience that ought to have a right to work there, to learn there, free of bias or harassment or discrimination of any kind.
Carrie, one quick question to you. You went through a major ordeal with your sexual harassment case. Do you feel that this kind of case trivializes the sexual harassment issue?
In one sense, I think it's good, like you're bringing it up and you're discussing it here, because you can discuss it. I think that's the important thing about harassment, is the only way to prevent it is to talk about it and come to some agreement. I mean, really the last thing you want to do is show up in court and go through 8 years of hell.
On that point, it's time to put this question to our jury. Is the right not to be sexually harassed greater than the right of free expression? Final Take has the verdict in just a moment here on Lifetime. Some closing arguments on sexual harassment. Our final take for tonight. when we come back.
Women do not have to go into the workplaces, Mel, with bags over their head.
Welcome back. I'm joined once again by our foreperson, Ramona, who has our audience verdict. Now, remember, the question is the right not to be sexually harassed in the workplace greater than the First Amendment guarantee of free expression? And the verdict?
The verdict of the audience was that the guarantee of free expression was greater than sexual harassment in the workplace.
And so the vote was?
The vote was 2-to-1.
2-to-1
in favor of free expression, so the painting remains.
Okay. Thank you very much, Ramona. Now our audience will have the opportunity to ask the questions they've thought about here tonight. So we're going to turn to you now and find out who has the burning questions. Let's see some hands up here. Your question.
Since Gloria seems to agree that harassment is in the eye of the beholder, could I then feel offended by a low-cut dress that a woman might be wearing in my workplace? Could I have her cover up if that offends me?
Well, it's really going to be a question of not only what you find to be hostile or abusive or sexual harassment, what would a reasonable person in your situation feel is hostile or abusive. So I do think that it's a fair question, but really the question is, would reasonable people be offended by that or not, and how low is it? I think we know.
But you did agree with taking down the picture that the woman did feel was offensive. It was only her.
Well, I mean, it doesn't have to be everybody agreeing. It also depends not only on your subjective judgment of what is sexual harassment or offensive or degrading or humiliating, but what would a reasonable person feel?
But a reasonable man would find that a woman sitting across from him in a very tight sweater, she'd be making a sexually explicit statement that would interfere with his job performance. It'd be a hostile working environment for most men. Is that sexual harassment? You're not really answering his question.
But it really depends. And the question is, he didn't say anything about sexually explicit statements. You added that
A woman in a very tight sweater is making a sexually explicit statement.
Well, let me just say, I think that women are generally entitled to wear that which is appropriate to the workplace, and it's a case-by-case situation.
But men are not permitted to speak their minds.
Women do not have to go into the workplaces, Mel, with bags over their head or long gowns or completely shrouded the way they are in Iran. We're not going to stand for that, and you're not going to put us back in the veil.
And I don't think men should have to go into the... And I don't think men should have to go into the workplace with gags in their mouths.
One final concluding
What
statement.
we're trying to do is humanize the workplace, and we're trying to get people to understand what it's like to be on the downside of a power dynamic and to recognize that we don't want a tyranny of the majority, that my way is not the way, my way is a way, and we need to talk about it.
We've got another question up here, okay? Get to you.
I don't know whether the lawyers could answer this or Carrie, but I heard in both segments about 6 years and Carrie 8 years. I'm sorry. And then I heard appeals. After you're awarded $3-something million, I heard these big dollar figures, all our eyes popped open. Then I heard appeal. When and how long do you have to wait before you see, or someone else who files the suit sees any cash?
One of the reasons I settled out of court is because appeals can go on forever. You know, that's a hazard. Was it worth it for me? Yeah, it was worth it for me, partly because whether you go to court or don't go to court, for me it was very cathartic, actually, to go through the process and do something positive about my situation that would help other people. I've talked with women who have been harassed and have not done it, and I think they carry a lot of guilt about that, and it affects them the rest of their lives.
Well, it's been a very informative hour. Obviously, many new questions are just beginning to surface. The issue is far from resolved, but I hope we've shed some light. Thanks to our panelists, our audience, and thank you for watching this special Lifetime presentation of Final Take. Good night.
The same behavior in one context between two people is perfectly welcome. The exact same behavior between two different people with a different power relationship may be unwelcome.
When this first happened to me, I didn't know what sexual harassment.
Beauty of America on Wild Discovery. Then explore the world of insects during the dinosaur age on Sci-Trek and begin a 3-day journey through a mysterious land on realms of the Russian bear. Coming up on the Discovery Channel.